Respected members of the Judiciary, the members of the bar present over here, ladies and gentlemen, a very good morning and assalamu alaikum to everyone. Today I would like to take this opportunity on behalf of the Legal Aid Society and MICADR International Center to thank the CLTP and ICLP ADR International ADR Center for inviting us, for hosting the symposium and giving us this opportunity to be present amongst all of you to give a regional perspective on Pakistan and talk about the enforcement of arbitral awards that's taking place in Pakistan. I was, two months back I came to Sri Lanka for a yoga retreat, and we were taken to a shala which was 2 hours away from Colombo, and it was a brilliant experience. We were in the middle of nowhere. We would get up every morning, listen to the voice of forest and jungle, and it was a great experience. So it was a good break from the hustle bustle of Karachi. On my last day, when we were going back to Pakistan, one of my friends over there, I told her that it's a beautiful place and I think I will come back soon. I did not know that at that time I was manifesting that I will be sitting here right after 2 months talking about the regional perspective and how arbitral award works and the enforcement of arbitral award works in Pakistan. It is indeed a pleasure. I would like to start with a story which is very close to my heart, and it's a real life story that the case went up to the Supreme Court of Pakistan. It is about a giant multinational construction company that entered into a partnership for development of infrastructure with the Pakistani entity. Now, on the face of it, everything was going fine, but the parties, which is inevitable, disputes are inevitable, the parties entered into a dispute. And then the money was retracted, there was delays in the project. It seemed like there's a dispute between two entities, but if you step back and if you see, the dispute impacted the individuals that were involved in it. The project manager who was overseeing, it was a matter of a lifetime for him to kind of supervise this project supervise a project that has national importance. Because there was a foreign company involved with the Pakistani entity, but at the same time there was another girl who had to fight her parents to, the patriarchal society that we operate in, she had to fight her parents to be able to be part of this project. Her name was, I'm using hypothetical names, her name was Maria, the other guy was Asad. So you see, on the face of it, it's a dispute between two organizations, two entities, but if you step back and see, it is a lot about Marias and Abdullahs and Alis that are involved in when there's a dispute between parties. Luckily, the award was enforced in Pakistan, but it was more about how we view Pakistan, the national stake, the Pakistan, whether Pakistan is a good country for foreign investment. How are the arbitral awards enforced? Everything was, other than the emotional aspect of the dispute, everything was at stake. So and this was not the case a few years back. The judiciary in Pakistan has now become very arbitration friendly. So imagine for a foreign investor to invest in a country where you know that if you go to litigation, even for arbitration, your case would take not less than 25 years. So that changed the trajectory of this decision. They changed the trajectory of how foreigners look at us now, how international arbitration, how enforcement foreign awards is playing an essential part. Having said this, I would like to start with giving a legal framework of the arbitration regime that is working in Pakistan. There are two legislative frameworks. One is the Arbitration Act 1940 that governs the domestic arbitration law in Pakistan and domestic awards. And then we have the Recognition and Enforcement of Foreign Arbitral Award Act of 2011. Now we'll first talk about the domestic award, which is governed by the 1940 Act. It is unfortunate, and I guess Pakistan is the only country that is still, having its award decided under the 1940 Act. But there's a good news. Before I was coming here, last week, the Law and Justice Commission of Pakistan handed over the new Arbitration Act, which is based on the Arbitral model law, to the Law Minister of Pakistan to present it before the National Assembly. So this is actually a good news for us, and I'm glad that I have this opportunity to talk about some of the salient features. As I told earlier, it is based on the Arbitral model law. Then the courts have shifted from taking an interventionist approach to a supervisory role. And in the 1940 Act, there is if an award has been passed, it has to go to the court will issue an decree, and then it will be enforced. Whereas the Arbitral model law suggests, and what the new law in Pakistan is going to look like, is that the award would be enforced as it is. And then there's a provision that the cost will follow event. So if there is, if the arbitrator of the court is able to ascertain that there was a frivolous or unfounded claim, that the cost would be imposed. So the concept of cost, it's very common throughout in many jurisdictions of the world. It is still very rare in Pakistan. So we take this as a win. And then this new act enhances the country's attractiveness as a venue for international arbitration and for foreign investment. Now, these are some of the salient features that I was able to put before you, salient features of the new law. But what are the loopholes in the 1940 Act, which Pakistan is still following? In the 1940 Act, the judges or the court has a greater part in scrutiny of the award that has been passed. And I will give you an example. Award can be, under the 1940 Act, an award can be modified or can be corrected. But in addition to that, by the court, right? But in addition to that, the court has the authority to set aside the award on the basis of misconduct. And now, if you ask me, how do you define misconduct? It is such a wide term, it's such a broad term, and it was usually up to the discretion of the court to interpret how would they define, how would they interpret, what misconduct is. The judges, as I told you, in the last 3 to 4 years, have taken very serious steps towards making arbitration or to making country an arbitration-friendly country, and they have given a non-exhaustive list of what can be construed as misconduct. So misconduct can be construed as failure to decide all the matters referred to the arbitrator. Then deciding matters not included in the agreement. Then if there is inconsistency or ambiguity in the award that's been issued. But again, this exhaustive term was still very wide, and the judiciary and the court was given a lot of power to set aside awards, which should never be the intent when parties are consensually agreeing to mediate. In last year, 2023, the senior union judge of the Supreme Court gave a decision in which he very categorically noted that unless and until there is a grave miscarriage of justice, the courts in Pakistan do not have the right to set aside an award. So this is how the court would set aside the awards on the basis of having discretionary powers. Now coming to a point where the jurisprudence is developing in such a manner that the award would be set aside if there is grave miscarriage of justice. Now, if we take a step back, in 90s, how the courts were deciding cases were the court has a judicial power of judicial scrutiny. At the same time, they were wielding discretionary powers. And it is unfortunate, but some of the cases that were decided, the arbitration agreement was not endorsed or was not upheld in one of the cases because the court with all due respect, thought that it will be an added expense to the party if they have to go to Paris for arbitration. Then similarly, there was another case where the Supreme Court restrained a party from pursuing exit arbitration against the government because the government came to the court, the government entity appeared before the court and said that we are waiving our right to be in this arbitration. Then there was another case in which there was an allegation of corruption and the matter had to be arbitrated. The court said that this matter cannot be arbitrated because it involves criminality. So it's unfortunate how things were happening and how things are still happening in Pakistan. But as I said, we have good news that the 1940 Act is being repealed and soon we will have a new law. Now I would like to move towards the enforcement of foreign arbitral award because I'm assuming that will interest everyone more over here. So as I told earlier that the foreign award is governed under the Enforcement and Recognition Act of 2011. Now before that, there was the foreign awards was governed under the Geneva Convention of 1923, and again, which as Judge said that we have the New York Convention has limited grounds. The grounds that were given in Geneva Conventions were again very wide. And unfortunately, the burden of proof if the party was on the party that wanted to get the award enforced, not the other way around, which is now the case in the New York Convention. And then there were two-step processes. The one was for confirmation of the award in the country where it's being issued, and then the second was in the country it was being enforced. Unlike what is given in the New York Convention, that an award, and which the same view has been taken in the new law that's before the National Assembly now, that if an award has been passed, the role of judicial scrutiny has to be limited, and the award would become a decree as it is. So now things have changed. Pakistan has become an arbitration-friendly country, but I would like to discuss how the jurisprudence has developed. There was a case by the name, the company in that case was Hitachi. In that case, the question before the judge was regarding the nationality of the award. The award was rendered in Singapore, but the governing agreement was governed by the law of Pakistan. So in that situation, the opinion that the court held, and the judgment that came about was that this will be construed and the award will be rendered under the 1940 Act, not in accordance with the seat of the arbitration. But then the judges have now taken a very strict stand, and there has been a shift towards aligning with international standards, demonstrating a pro-enforcement bias. And I will give you an example of a very recent case which came about like 2 months back, in which